I'm glad you're signing up for this Crisis Management for COVID-19, Phase 18. We're 21 weeks into this crazy thing. How about that? We're going to get an update today and guidance on legal changes and legislation. And it promises to be a lot of fun. I see people already putting some chat comments down there, so that's great. Keep an eye on that chat box and let us know what you're thinking, and we're glad to respond to some questions. We've got a great guest with us today. If you'll flip that slide one more spot. And I'm going to press on, and I'm going to hope the slides catch up. We're going to start off today hearing from John Yarmuth. He's a congressman from the 3rd District in Kentucky. That's the area around Louisville. He's in his 7th term, and we're just delighted to have him on here from some new perspective and an update on what's going on in Washington, D.C. John is, in addition to being a congressman, he has been elected to be the chair of the Budget Committee for the House, which is a big deal, and we're proud of him for doing that, and that gives us access to a lot of good information and his good influence. He really focuses a lot on improving education, on expanding affordable health care for people, and he's been working on revitalizing manufacturing in and around the Louisville area. He's a Louisville native, went to Atherton High School, where my sister went. I'm proud to have him on here for that good reason. And he also attended this small school out east, Yale University. So, John, we're just delighted you're here with us and looking forward to your comments. Let's just take it away, John. Tell us what's going on. And I know you've been there all last week, flew in on Friday night. How are things going?
Oh, they could be a lot better, Lyle. I can say that. First of all, thanks for having me on your series. It's very important. And I just want to say that from day one of this crisis, which as far as the Congress is concerned was about March 14th, that was the last day we were in session before we had ceased for a while. Of course, we were aware of what was going on in Washington State, what had gone on in China. But in terms of thinking about legislative responses, it was really early March before we thought that we were going to have to step into this crisis. So over the ensuing 2 months or so, we passed 3 different pieces of legislation. They totaled about $3 trillion in spending. The last was what is known as the CARES Act, and that was passed on May 15th. And that did a number of things. It provided for the PPP program, the Paycheck Protection Program, which gave money to businesses to keep their employees on the payroll. We passed a supplement to unemployment benefits of $600 a week for everyone who was on unemployment. That's in addition to what they were getting from their individual states. We had some money in there for state and local governments to help them defray the costs of dealing with the pandemic, and a variety of other provisions. At that time, some may recall, Mitch decided the Senate was, aside from calling it a non-starter, which is kind of par for the course, we often consider what the Senate sends us as non-starters as well. But he said he was going to take a pause and see what we needed to do. Now, I don't usually defend Mitch, and most of my comments subsequent to this will not defend him. But at that point, I think everyone felt that this pandemic was probably going to be a 2 or 3 month issue, and that after 2 or 3 months, we would get a handle on it, we could contain it, and we could in some way minimize the economic impact of the disease. That's why, for instance, the Paycheck Protection Program provided for 8 weeks of salary for these businesses. And on the unemployment front, we scheduled that to be from May 15th till July 31st. So we all thought at that point that things were going to get significantly better by late summer. Well, it became fairly obvious as we went into June that that was not going to be the case. In spite of the fact that there was somewhat of an uptick in employment, if we were still seeing over 1 million people every week file new unemployment claims. We knew that the virus was still spreading, even though it had been contained in New York and New Jersey. It was popping up elsewhere. And of course, now we've seen a vast uptick in new cases, in deaths, and in the economic impact. We saw last week the GDP for the second quarter dropped at an annualized rate of 32%, the most it's ever dropped in the history of the calculation. And so we're in a crisis situation. And like I said, we knew that before last week and before the week before. And yet the Senate did not start deliberating what they wanted to do until about 10 days ago. That was the first time they ever had any conversations. So here we are, where the unemployment supplemental has expired. So people are not getting that federal supplement this week and won't until we do something at the federal level. We had in the CARES Act a protection against eviction. That has expired. That expired on Friday. So now people can be evicted from their apartments or their homes if they have federal involvement. And we still see, again, escalating crisis. So the big problem we're having right now in Washington is that in a normal negotiation in Congress, it's a two-way negotiation. The Democrats have a position, the Republicans have a position. This is far different than that. In today's dynamic, it's about a 4- or 5-way negotiation. So in the Senate right now, we have 15 to 20 Republican members who said they are not going to vote for anything. They are not going to vote for any additional relief from the federal government. Then we have Republican senators who want to do something, but want to do much less than the House does. Then we have Steve Mnuchin, who is actually probably on the Republican side the most pragmatic of all of the officials in the government. He is actually constructively working, I think, to do something significant. And then you have the president, whose position varies from hour to hour. So it's very hard to come up with any kind of serious negotiation and subsequent compromise if you're negotiating among so many different parties. And that's where we find ourselves. The negotiations continue today. We have Chuck Schumer and Nancy Pelosi on the Democratic side, Mark Meadows, the White House Chief of Staff, Steve Mnuchin, the Treasury Secretary, on the Republican side. Those are the 4 people in the room right now. Mitch is not in the room. Mitch has basically taken himself out of any leadership role in this. I'm sure he will brag about getting it done once it gets done, but right now he's on the sidelines. As a matter of fact, I think he's in Louisville today, supposedly holding a photo op with Alex Azar, the HHS secretary, about getting new testing equipment here, which to me is actually, it's a photo op for failure because it indicates how inept this entire effort has been since the middle of March. So anyway, that's where things stand. I'm fairly optimistic we will get something done within the next week. We absolutely have to get something done. We have consider this, we have 30 million people on unemployment right now. 30 million. If you take that $600 a week away from those 30 million people, which is what is happening now, that's $18 billion a week that comes out of the economy. Think about that. $18 billion a week, $72 billion a month, or more, $75 billion a month. That is an enormous hit to the economy. It's an enormous hit to every community. So we have to get something done. Washington is the only place that can solve this terrible, terrible crisis we're in. And I hope the sanest minds prevail and we're able to come to an agreement on something that will prevent a lot of pain and hardship on the part of the American people. And with that, I'll answer questions.
Great. Jim, Allison, Autumn, you want to, you got any summaries from our questions?
So there has been one question asked about the Ffcra. We've got a lot of issues with people who are traveling to hotspots, and our governor has issued a recommendation, but not a mandate, that people be quarantined for 14 days after returning from a hotspot. So in all of the discussions and the political rankering, has anybody addressed the fact that we need to have guidance for everyday employers on how to handle a 14-day quarantine and whether that falls under the Ffcra or not? Are they going to address the Ffcra with more particularity, since this was built as a temporary issue but clearly has turned into a longer-term issue? And how do employers address those issues and concerns? Is Congress coming up with any plans? That's the question that was asked about the whether emergency sick leave or the FMLEA is expanded to cover the governor's recommendation of a quarantine instead of a mandate of a quarantine.
I don't think there's, I'm not as knowledgeable in all of these things as probably your people are. The CARES Act actually, and previous legislation, actually, I think the first thing we did dealt with family medical leave, but nothing has changed since that original action. None of the legislation has changed what we did back then. So, and I haven't heard much discussion about that. Most of the discussion, again, in Congress has been over unemployment, further aid to business, aid to state and local governments, and the eviction moratorium. So, you know, if I can get an answer about that, I will shoot it to Lyle, and maybe he can provide it on a subsequent session.
Yeah, it sounds like, John, you all haven't gotten into these kind of weeds, and there are a lot of things that, like you said, you planned this to be a short-term problem, and it's a long-term problem. So now we've got a lot of details that are coming up that we need guidance on. And
let me just add one thing on that. And this is going to sound highly partisan, but trust me, it is. I'm not exaggerating. What the administration, what Trump and his team have done over the last 3.5 years has been to basically create huge vacuums in government operations. None of the agencies that are dealing with this virus has anywhere near enough people or resources to deal with it. That's been, you know, I just give you an example, and this is the State Department, but and they are not involved in this. But of the top 11 positions at the State Department, other than secretary, which required congressional confirmation, Senate confirmation, only 2 of those positions have anybody in them. 9 of the most important 11 positions in the State Department are vacant. That is true in virtually every agency, or you have acting personnel in those positions. At HHS, the person in charge of coordinating PPE is a dog groomer. That's what he did. He groomed dogs, and he's now in a very important position. So we've seen that up and down the agency. And so when we were trying to in the CARES Act, again, May 15th, to create some really significant large-scale programs to keep our businesses alive, to keep people being able to eat and pay their rent and so forth, we threw those on agencies that were already inadequately staffed. So, you know, and the bottom, getting to your point, the guidances that we would have normally expected from government have been very slow to come, have been disjointed. Most of them, sometimes they've been inconsistent. They've changed very frequently, and that's caused a lot of turmoil in the country with employers as well as with citizens. So we do have right now a dysfunctional executive branch of the government. And a lot of people say Congress is dysfunctional too, and I would not disagree with them. But the executive branch is unprecedentedly ill-equipped to handle this.
Thanks, John. You know, another little thing that we're getting some feedback here on these questions. One of the problems was that $600 was so generous on top of unemployment that some people, even when we gave them opportunities to come back to work, they did not want to come back to work because they were making so much more money than they would normally make that they were, you know, it was a disincentive to work. That now on top of child care challenges with school and people being quarantined for, you know, being involved in things that have gotten them close to the edge or something. Boy, it's hard now. Even though all these people are out of work, people cannot fill jobs. Isn't that crazy? You know, but so we don't want to over-incent them to stay home. That's that's not good for business. So I don't know that going right back to the 600 is the right thing, but all this needs to have some careful consideration because every action has an equal and opposite, whoa, you know,
yeah,
reaction.
Absolutely. Believe me, this is not the first time I've heard that.
Yeah.
I get it every day. There was a fairly substantial national survey done just within the last couple of weeks. It indicated 70% of the people who are now on unemployment would go back to work if they could, even if they were making less, if they made less money by going back to work. And the reason is that most people are sensible enough to know that this isn't going to last forever, and that ultimately their long-term interests are better having the job, plus they get their benefits back. So, but that still leaves 30% of people who would not go back to work. So it's a problem. I think the jury's still out as to how significant a problem it is, but we know it's an issue. When about 2 months ago, Speaker Pelosi asked me as chairman of the Budget Committee to come up with a piece of legislation that would be a standalone stabilizer proposal. And when I say stabilizers, things that stabilize the economy in a recession. And it involved basically unemployment benefits, SNAP, for food stamps, and Medicaid, the FMAP, which is the federal share of Medicaid to states. On the unemployment benefits, what we propose doing, and I think they're actually getting ready to work toward this, is continuing the $600 for period of time, maybe 30 days, maybe 60 days, ratcheting it down to $450 or so a week, and then rate falls beyond a certain point, then it gets lowered or eliminated. That to me is a sensible way to do it. You can argue over what the right numbers are, but that to me seems sensible. We in the CARES Act, we extended $600 a week to January 31st the next year. I think that's unreasonable, and that's why we came up with the plan to ratchet it down fairly quickly. So I think the Republicans proposed last week going to $200 a week, and then they proposed some formula where they would replace, the supplement would replace 70% of an individual's pre-pandemic income. But to be honest, that requires a level of detail that I don't believe state unemployment offices are capable of doing. We've had a hard enough time responding to the additional new applications. But to me, numbers are numbers, and numbers are the easiest thing to compromise on. And it seems to me we can find a number that tries to keep people above water. And that, again, we have 30 million people out there, almost, well, it's 10% of the almost 10% of the population, but much less, it's almost 20% of the workforce in the country. out of work. And they didn't do anything to deserve this. They did not do anything. Nobody did. And so the question is, who is going to try to keep their lives from going in an irretrievable position? And the answer is the federal government has to do it. I think $200 a week is ridiculously low. And also, again, going back to my calculation, you go from $600 to $200, so you're taking $400 a week per person for 30 million people out of the equation. That's $12 billion a week, which is still a pretty significant hit to the economy. So again, I think if right now, a month or two at the $600 a week and then ratcheting it down to 400 or 450, to me is a sensible approach.
John, what's happening with support for schools? Because we need to reopen schools so kids have a place to go, but it needs to be safe, and that takes a lot of effort and plexiglass and other things to make it work. What's going on in terms of trying to help our schools meet the needs?
Certainly does. So we had, I think, something like $150 billion in the HEROES Act, which was what we passed on May 15th. The Republican proposal that they put forward last week had $105 billion for schools. The kind of devious thing about their proposal was that 70% of it, of that $105 billion, was reserved for schools who went fully back into operation in place. So they had an agenda, which was to get people back in schools and not have hybrids or online instruction, which everybody would prefer. But they basically tied their hands with the money and said, well, of the 105, only 30 billion or so is available if you're going to provide alternative instruction. And by the way, a significant majority of Americans think that's the way we need to go. A majority does not believe we ought to be back in classrooms, fully back in classrooms this fall. So anyway, both the Republican proposal and the Democratic proposal did provide money for schools. And I don't know whether 150 or 105 is the right number, but we absolutely have to help the states if we want any kind of education system this fall.
But none of that has received a final vote, right?
None of that has received a final vote. And by the way, the proposal that we put forward, the HEROES Act, had almost $1 trillion for assistance to state and local governments. And there have already been 1.5 million state and local employees who lost their jobs or laid off from their jobs around the country. And a lot of these are teachers. So there's that component to the education problem, as well as the safety component.
Okay, so is the Congress, we're going to wrap up here, but is Congress still in session, or did you all come home?
So we are in what is our annual, we started on Friday afternoon, our annual August recess. Both the Senate and the House take August off historically, going back 200 years. And the Senate is in session this week, and then they're scheduled to go out for their August recess at the end of this week. We're on 24 hours notice to go back to vote on whatever proposal ultimately is negotiated.
You all can't vote remotely. You have to be there to vote?
Well, the answer is we created this year, because of the pandemic, a system for proxy voting, where if you don't feel safe, or if you're, I'm 72, so I probably shouldn't be traveling and going there myself, but I do. But some people justifiably don't, but they now can vote by proxy. So a member who is on the floor actually consults with the remote person. The remote person tells them how they want to vote. They get up and announce the absent member's vote, and it appears as if he or she were in the chamber. So it's a form of remote voting, but it's not pure remote voting. We did authorize a system. We did authorize the possibility of remote voting once the technology is available and secure. So you might see that someday in these kind of situations, but I would say right now about maybe 40 to 50 members are voting by proxy out of 430. So it's being used, but not abused, I think.
So most of them are there. Well, we thank you for being with us today. And obviously it's complex and we need help, in on a lot of different fronts.
Absolutely.
And we'd love to keep you on our list and share some of the feedback we get, because we got a lot of important employers out here representing, we think 50 to 70,000 employees. So it's a lot of people we're in touch, that we can impact.
Absolutely.
And
Absolutely.
stay after it. We appreciate it.
Okay. Thanks for having me on.
You
Take
bet.
care.
Thank you very
Take care.
much. All right. Topic, we're going to turn this over to Jim Morris. And if you're new on the call, we welcome you. Jim is an attorney with Morris & Morris and has a JD and an MPA. And he's really keeping us up to date. Somebody said, the guy tells it like it is, and that's it. So Jim's got a lot of stuff to share with us. And Jim, we appreciate you keeping on top of it. I know things are changing every minute. Take it away. Let us know what you know, and we'll fire some questions at you too.
All right. So if you thought I was unvarnished before, today's probably a great day to listen in, because you're going to see unvarnished again today. Some people have sent me notes going, I love it when you just say what you feel. So you're going to see a lot today, because there's a lot of stuff going on. We'll start out with the nuts and bolts, and after that, then we'll go forward and I'll address some of the frustrations and concerns. So having trouble with my slides, so I've got to do it manually. So let me see if it'll work this time. Nope. So just hold on just a second. I don't know what happened to my, there we go. Okay. So I'll have to look that way every once in a while and make sure it's still working. So the House and the Senate have two different versions of what's going on. You've just heard some of it that we just talked about with Congressman Yarmuth. Basically, what I try to do is I try to stay out of the politics, and I try to make this only about what will help Kentucky businesses and how to walk Kentucky businesses through things. I have companies and friends that are diehard Republicans. I have companies and friends that are diehard Democrats. Everybody loves to blame each other, and I don't think it's right to blame anybody right now. It's just right to walk you through it. So I'm going to stay out of the politics still and walk you through what I see. So when I talk about the House, when I talk about the Senate, the reason why I said Democrats on one side and Republicans on the other, just in case you have been living in a cave, House is controlled by the Democrats right now. The Senate is controlled by the Republicans right now. So that's why I say Dems on one, Republicans on the other. As of this morning, they were continuing to debate. They were going to be meeting, I believe, right at the beginning of our webinar, but there are no decisions that have been made. Trump administration has sent Mark Meadows and Steve Mnuchin to meet with Schumer and with Pelosi. I do want to say one comment on the politics that we heard a little bit about. The reason why McConnell's not there is McConnell is not the key right now. The key is to figure out from a House perspective, how do we get the House to agree to some of the Senate's proposals. Trump believes he can get McConnell to get enough votes in line as long as he can pull some of the Democrat votes. So that's why you have the two players on each side. It doesn't include Trump. It doesn't include McConnell. It doesn't include minority leadership in the House either. It only includes majority House with the minority Senate with the two people from the administration to try to get it done. These are the key things. I'm trying to read the tea leaves because there's a whole lot of confusion. These are the areas of dispute, apparently. Mail-in voting, the Democrats or the House, I'm sorry, I'm going to keep this House and Senate. House wants to change mail-in voting as part of the COVID spending bill. The Senate said no. The House wants to put aside $25 billion for the United States Postal Service, and the Senate said they wanted $5 billion. SAL is state and local. I'm sorry, I didn't want to take up the whole page. The House wanted, I believe, it was $105 billion additional for state and local. Actually, that's not true. I think it was about 500. But the Senate said they want to lift some of the restrictions on the previous money that went out in Phase 3 and allow state and local governments to utilize that money without some of the strings that were in there before. Unemployment. The House and Senate appear to agree on $600, but the House is saying they will not allow a vote on a temporary spending measure to allow the $600 to go forward that Mnuchin and Meadows suggested, unless the Senate will agree to the entire HEROES $3.4 trillion or whatever else that they can come up with. They will not do a temporary spending. So that's where the hang-up is right now. It's not on the $600. It's on, one, how long will the $600 continue? And two, can we do this without a full HEROES type, that's what they call it, that's the initials for the act, without the full HEROES type bill being approved by the President and the Senate. That's the hang-up. The Senate has suggested that they want a short-term get back to work, and they've also wanted to throw in there some type of incentive for people, and that was one of the questions you all are asking in the chat session was, we want people back at work. How do we get people back to work? We need to incentivize getting them into the workforce, not paying them to stay at home. That was one of the things the Senate had in theirs, was some payments made to people to incentivize getting back to work instead of the $600 to stay at home. If you go back to week 6 or 7, you'll remember we actually had a breakdown where minimum wage in the state of Kentucky was in excess of, I think it was $35,000 right now. It's hard to get people to go back to work if they're being paid more money to stay at home than they are to go to work. That was the issue that was raised. The discussion about 600 is not really the issue. From what I can tell, the issue is how long will that continue, and are there other incentives? House says no incentives for return to work. That's the last issue on the screen down there. Senate says yes. The House wanted to, I'll go in order. Food stamps, the House is demanding the Senate proposal. Housing, the House is demanding additional money for rent subsidy / mortgage, paying people's mortgages and rent. The Senate is saying no. And then the business, school, and charity liability, if you recall last week we had Congressman Barr's Chief of Staff on. It was mentioned that the big push was the desire to have some type of limitation of liability for people who are adhering to governor mandates and local mandates, and if someone happens to get sick, can they get sued? The House is saying no limits on liability. They don't want any protection for businesses. The Senate is saying, yes, we want protection for businesses, schools, and charities that have done their duty, but COVID causes issues. They want some kind of limitation on people being able to go file lawsuits. So those are the things that are still being debated. This is what's been agreed on. You'll notice quite a bit smaller list of what they're agreeing to. Apparently, they both agreed to the $1,200 stimulus check. That does not help anyone that's lost their job that made more than $75,000. I've been begging either side or both to be addressing this based upon a last quarter instead of last year's annual. Does not appear that that's going to be addressed. So if you made more than $75,000 last year and you are now unemployed, there is no compensation for you under the stimulus calculation unless something changes last minute. Continuation of unemployment benefits, amounts to be determined, but both sides are agreeing on some type of continuation. Back to school financial assistance, both sides are talking about it, whether it goes to PPE or whether it goes to the schools. That's yet to be determined. The one thing I've seen a lot of comments in the chat. The chat session had a lot of questions about what about us as stay-at-home parents? How do we come up with some type of money for us and tutors and private education and so on? Zero discussion on either side that I can find that actually is end user, as I would call it, that would actually go to the person that needs the money to figure out how to get their own child into school, whether it's finding someone to get them through the day so that they can go to their job at Hardee's or McDonald's, or whether it's because they need to actually do their accounting, legal, HR job, and they can't find anybody to watch the child during regular work hours. Nothing yet on that side of it. Disappointed that neither side has done that either, because that's the end user. If they're trying to help people, right now schools don't need the money because schools don't have any heating, air conditioning, getting people into the schools if they're going to be remote learning. They do need to get training for their teachers. They do need to figure out how to do the Zoom meetings. They do need to get, for those that don't have internet at home, they need to get internet to all the parents and all the families, but they don't need the same level of support they've had in the past. And one of the questions somebody asked me is, does this mean our taxes are going to go down for school taxes? Because if they're not needing their physical buildings and they're not paying for janitorial, they're not paying for bus service, they're not paying for the rest of it, what are they doing with all the money that they're collecting off of the property taxes in Fayette County, Jefferson County, and so on? So that's a great question, and I think it bears out some, if you want to get political, and I'm not going to, that bears out some real issues for local school boards. They should be hoarding their cash so that they don't have to collect taxes in the future. That's the way that they should be using the money to be protecting people and to make our economy get back, is don't charge people taxes if you don't need the money because you didn't have physical apparatus you had to clean and disinfect and so on. And then also Congress should be looking at end user. The last thing everybody's agreed on is COVID-19 testing assistance. That's been in every bill since the first or second one. There are 4 things they agree on. There's a whole litany of things they don't, and that's something that's disappointing. I think fault lies everywhere, so I'm not going to get into the politics and blame game, but they have a long way to go to get this. And the one comment that I loved in the chat session, and there were several of you, so I'm not going to attribute it to one, we're in the middle of a pandemic, and I'm working my tail off every day to figure out what Congress is doing. I spent all day yesterday trying to read the tea leaves. I don't know how they can go on a summer vacation during the middle of a pandemic when the rest of the economy is trying to figure out what in the world are we supposed to do. So I'm with you. Those comments, I loved them because I can't believe that we're talking about going on recess, because it's just what we've always done, because right now is not what you should always be doing. You should be moving on, trying to help the economy and help small businesses. So.
Can we have an amen?
So, all right, here's some updates. Now that we're into updates and out of the politics, I'm sorry, not politics, out of Congress, I have no update for you on Congress other than the tea leaves I put on the first screen and the apparent agreement on the second screen. I wish that they were all actually working on this. I do think I've told you all, he just mentioned the remote proxy voting. From a legal perspective, I believe the proxy voting is illegal. I think it's unconstitutional, and this is going to create several issues that the court system is going to have to address, because you can't adopt a proxy vote by proxy vote, which is what they did back about 6 weeks ago. And so there's a real issue with the manner in which it was done, and there's a real question about whether you can allow other people to vote harvest and then bring in their stack of votes that they got from other senators or congressmen. This is only in the Congress, not in the Senate yet, but voting by proxy and allowing people to is frightening. So I don't know that that's going to last that long. EEOC update. So on July 27th, there's a brand new update. Just want to make sure it's there. It updated an April 6th memorandum I mentioned in week 2 or 3 about the handling of EEO complaints during the pandemic. On April 6th, they basically said we're shutting down operations, we won't be issuing any decisions, we won't be ruling on appeals, and we won't be sending any mail out. They have updated it. Yes, this is not a huge update, but it does mean for HR professionals that things are starting to move again. Decisions are going to be made. They're taking a very slow approach on decisions, but they changed, they said going back to a semblance of regular operations. Instruction number 6 said return to issuing final decisions, but be mindful of the employee and the fact that the employee may not be ready and that there might be issues, so please don't make a final decision with a rashness, basically. But final decisions will be issued. Number 7, appellate decisions will be issued by both mail and electronic instead of only electronic. And number 8, you can use the public portal, and they're encouraging the public portal, but it is not mandatory so that they don't have U.S. mail. Some of this goes back to the early days where everybody was spraying their mail and everybody was worried about quarantining mail for 24 to 48 hours. They've lifted some of those restrictions, but the rest of the April 6th memorandum is still in effect. So that's the update on the EEOC. I know it's not much, but I wanted to make sure that you knew kind of where we are with it. There's a new announcement on safe at school, healthy at school, sorry, return to work or return to school. The CDC has stepped in. There's nothing earth-shattering here, but since we did have some updates about the return to school, I wanted to walk you through the one that came out on Friday, Saturday. Basically, the key guidance for K to 12, they want to make sure that you open schools based upon the community in which the school's teachers and staff live. Approaches to interaction with students, in other words, class pods, staggering return to the facility, only having students around one teacher, not around multiple. So instead of having students go from teacher to teacher like they do in middle and high school, one teacher for one pod the entire day and not having them switch. They talk about cohorts of students. I called it podding instead in the 4th bullet down there. They've suggested the 3rd bullet utilizing of unused or underutilized school spaces and outdoor spaces. I don't know what district they're looking at, but in Fayette County, as soon as we build a brand new school, we're already using an outbuilding because the school's already overcrowded before it ever opens. So we don't have any spare school locations unless they're talking about the football field, the soccer field, the baseball field, and the playground. There are no extra, janitorial closets or empty rooms for people to use. They've been long since gone. So, but they do say use those spaces and the outdoor. They want to use multiple strategies. We've talked about that incredibly a lot of times, so there's no need for us to go into it in depth. Communicate, educate, and reinforce personal protective behaviors. That's your mask wearing and so on. Social distancing, limiting participation. This is one that concerns me. Limiting participation in activities where social distancing is not feasible. Since this is a CDC guideline, I can see the end of bus service in Kentucky based upon this directive because you cannot social distance on a bus. Maryland has already said that you have to get your child to school, but you have to do it on your own dime and your own time because we won't send buses. I see this being a potential for Kentucky to jump on to cancel buses. Also, I see all extracurricular activities being shut down. There will be no chorus, no gym, and no football, baseball, basketball, or after-school activities. Chorus because of singing, band because of the instruments and the blowing into the instruments, and football, baseball, basketball because and soccer, everything else, because you can't enforce social distancing in a contact, semi-contact sport. So be prepared for that to come based upon the CDC guidelines. Again, CDC is not the law. CDC is a health directive, but yet some of the states are taking it to the extreme and adopting it as if it is the law. So I see this being overused, and you may end up with some problems in our system. Just telling you as it is. This planning and preparing for when someone gets sick is like, come on, that's common sense. We've done that since the 1800s. If you're sick, you're not around other kids. Working with state and local for contact tracing, that's already the law everywhere, and communicating appropriately to families about home-based symptom screening, that's everywhere as well. But that's your update from the CDC. So, all right, didn't move. I thought it would. All right, new guidelines for Nlrb. Since I have businesses on the phone, I said I wanted to keep this to business, or on the webinar, I wanted to keep this about businesses. These are three huge updates from the Nlrb. GC is General Counsel. If you haven't been on these, that's how I refer to myself and to General Counsels. So I also do it for space considerations. But on July 21st, there were several pieces of new guidance from the General Counsel for the Nlrb. First, a couple of caveats. Advice memoranda that come out from the General Counsel are not law. They do not have the force of law. However, the reality is, if the General Counsel comes out, gives a direction to a local regional office and says, we are going to do A, B, and C, or you need to do D, E, and F, that means that the local either will or will not follow, because that's the guidance from the General Counsel. In this instance, all three of these were helpful to employers, so I put them in here. First, Mercy Health, that's just the name of the case or the name of the issue that was in front of them. If anybody needs this information, I've got it. But basically, there was a unilateral change to the work from home and attendance policies following the pandemic. The union came out and filed a union complaint because you can't do that without alerting the union. And the General Counsel said the work from home policy didn't apply to the unionized employees, so you're not entitled to any notice, so it didn't affect them go away. The second one was changes to the attendance policy without notice to the union. It's understandable in the circumstance of a pandemic that you don't have to run to the union, alert them to every single step before you take it, because you had to do some things on the fly and then alert them afterwards. Basically, we're not going to challenge employers for doing something as quick as they can, and we're not going to punish them and allow unions to come in and file a complaint based upon solely the lack of notice as a result of the pandemic. Also, and this is in the last bullet down at the bottom, an employer should be permitted to at least initially act unilaterally during emergencies such as COVID-19, so long as its actions are reasonably related to the emergency situation. That's critical for all of you who are making decisions that have a collective bargaining agreement, because this means you don't have to rush to the union, wait for their decision, hear all their objections, get embroiled into challenges with courts and with the Nlrb before you need to make a decision in the middle of a pandemic. So that's big news for employers. I want to put it on there. Next, Larry Peel, another case. It's named after the employer. It's nothing else on that. The employee wanted to work from home during COVID. They engaged in a bunch of chat messages back and forth between the controller and the individual employee, and then the employer let the employee go. This is a big one because basically what it said, employee said, hey, I was engaged in protected activity complaining about the employer's COVID-19 health concerns, the work from home strategies, all of the steps the employer's taking. And what the Nlrb attorney general counsel has said, no, texting back and forth is not a legitimate complaint. It doesn't arise to the same level as a complaint about your employer, so you're not entitled to any protection under the law. So that person got discharged, not engaged in a protected activity by chatting or texting with his or her controller. I would tell you, you need to be careful, though, with your employees that are managers. Don't have your managers engaging in private discussions, because that could become water cooler, especially in group chats or in Facebook or private messaging on LinkedIn. You have to be careful about all of that because you could be deemed to be surveilling or monitoring the activities of your employees, but this was a one-on-one. The union attempted to challenge it, and they said, no, not going to let it happen. RS Electric is the next one. Honestly, guys, if you're in a union and the union's doing this, I've got a real problem with that union. I'm okay on either side. I do a lot of union training. I try to walk the fence and be careful on all of these. But this one, the union objected because the employer didn't give a 1 hour or wouldn't let them in to their facility without a 1 hour notice to be able to be ready for them with masks, gloves, cleaning supplies, making sure that everything was healthy for their employees under the state law and mandate of the governor. Union actually filed a complaint because they said we're allowed in on, quote, reasonable notice, so we don't need to have 1 hour and you wouldn't let us walk in the door unannounced, so we're filing a union charge with the NLRB. In a pandemic, seriously, that really, I saw that and I was like, that's just childish, because we all have to be screening people, verifying, making sure that wherever you're going is clean, that you stay away from all of your employees so that we don't have a pandemic go through our facility. If the union is marching in without any notice, we can't protect all of our employees from potential health hazards. So I agree with the employer on that. I agree with general counsel on that, and I couldn't believe that the 1 hour notice in the middle of a pandemic. Quit being childish is my answer. The last one's called Children's School Service. I'm sorry, the underline's not underlined on service. Reassignment and layoff of unionized school employees during a pandemic. It was challenged by the union. General counsel said the decision to lay off employees was within the compass of the collective bargaining agreement that allowed for the employer the right to act unilaterally in this situation. So you have no rights during a layoff caused by a pandemic where there's no school left to do. And then regarding temporary assignments, the general counsel held that the pandemic caused exigent circumstances, and that allowed for temporary assignments, so they're not going to hear the issues. So that is your NLRB general update. Next, whoops. All right, I've kind of stayed away from this for a little while, and now you're going to hear the nitty-gritty of the Kentucky Unemployment Insurance update. So, I issued an Open Records Act demand on July 21st for Kentucky Work Share because I've kind of had it. We're at the end of the $600 for federal. I got all kinds of notices from people after the last webinar saying, no, we're getting work share, but please don't use our name because we don't want them to come down on us. But no, we have work share right now for our employees. Right now it appears if you were a big company and you e-filed, congratulations, you got work share. If you're a small company or you didn't e-file, you didn't get unemployment work share. Here's what they did in response to my Attorney General about the fact that they're not the Attorney General, I'm sorry, the General Counsel for Kentucky Employment Workforce. So I had it with General Counsel, not the Attorney General. Here's their response. They issued a letter to the registrar, the regulations compiler, and I'll just read the first sentence. The Education and Workforce Development Cabinet Office of Unemployment Insurance is requesting the withdrawal of the short-time compensation emergency regulation effective July 22nd, because I walked him through and said it is the law. 787 KAR 1:350E is most certainly the law. It is mandatory. It even has in it, if the federal government Department of Labor does not adopt this, that the employer has to pay a portion and the work share department will pay a portion. So this was what they did in response, was they, one, canceled it, but that doesn't help them because of this. They have a full-blown application that they were forced to give to me that exists. If you got one of these, I'd love to hear from you. You don't have to give me your final version of it, but if you happened to have gotten this from the Kentucky Education Workforce and Development Cabinet, please send it to me, because only a select few of you actually got this. It's a full-blown application. I'm waiting for who turned those in. Nobody's in trouble. This is, except, well, unemployment's in trouble because this is not appropriate to have different companies getting this and other people not getting this. But this was the application that should have been released. I don't know who all got it. This is the next, sorry, they declared on Friday to me in a letter. There is no work-share, so we don't have any work-share documents. All right, so here's the work-share documents. April 23rd, I did block out the name of the person sending. If you see your email here, I'm sorry, but it is open records, but I blocked out everything I could to remove anyone who has their name associated with one of these. April 23rd, starting April 27th, these employees' hours will be cut from 40 to 24. Our hours have decreased due to so many of our buyers being closed because of COVID-19. Our restart date is not definite because it depends on how soon the economy restores and our buyers reopen. Any questions, please contact us at a number that's blacked out. The completed file was too large to send, so I had to zip it. Then the response from Lindsay Ransdell that runs KEWES. This is a reduced employment insurance e-claims, Rebecca Tabor. Next, make sure I've got it on here. April 14th, email, I'm not going to read each one. Weekly furlough e-claim file and reduced hour e-claim file for people. I understand it's required for the employer weekly. And then there's the file on the right is a reduced hour file from unemployment office to the head of the office. Next, 3 employees who are on work share, reduced salary, so it's not just hourly, attaching a work share e-claim for the weeks being submitted, and from Rebecca Tabor to Lindsay Ransdell and Megan Mitchell, FYI, work-share files. Next, I have one blacked out, but there was quite a discussion about the steps taken to make sure, there's a whole bunch here, back and forth, starting on April 10th. Work-share claim for salary employees for the week of April 12th to the 18th, added one more employee to the group, otherwise the list is the same people. The answer is this is a work-share file. Then there is, these employees will be mailed letters explaining when to claim benefits. This is from unemployment to this employer. However, these will not be mailed until Monday due to the late submission of this file. I would advise contacting your employees via email to instruct them to file claims on Sunday, so on and so forth. Then there's another letter saying, great, I'll get started on the claim. Thank you for your quick response. Just to clarify, the unemployment insurance benefits would apply to both hourly reduction, non-exempt, and reduction in salary, exempt. And this is from the head of the entire office. Her name is Lindsay Ransdell. Yes, ma'am. Thanks. Regards, Lindsay Ransdell. These are ones you've seen before, but this is from the unemployment office to an employer, April 29th. Reduced hours or wages are an eligible criteria. Sim goes down through and explains precisely how they should do everything with unemployment to receive work share. Just a couple of other examples. This one says, starting from the bottom, the question was, what is the process if an employee has reduced hours here at Rockcastle Regional and continues to work their second job? How do they report earnings? The employee will report those wages from the second job the same way they report wages from the first job. When the employee logs in to request a benefit payment, They report all hours worked and all wages earned at any employment in the previous week. Go ahead and send us the file. I'm reading at the top now. Send us the file. We'll process as an e-claim so your employees can get in the system and hopefully enjoy some benefits. Everything we have received as WorkShare has been put in the system and are active as traditional unemployment claims. Now, I know from the dozen or so that I assisted, not one of them received any traditional unemployment claims. Not one of the WorkShares has been put into the system, and not one of the employees received the $600. I did hear over the weekend that similarly situated identical entities, one received WorkShare, the other did not, major companies statewide. And then within one company, front office received WorkShare, but field employees did not. And that's not the employer doing, that's the state. Next, last one. So there's a question on there. When we get WorkShare, will it be reduced after the time off and so on and so forth? No unemployment program is designed to pay a demand, all of the other lost wages, all this different stuff. So this is a response. July 20th email, question was asked, will employees working a reduced schedule still receive state benefits even after the federal $600 benefit stops? Answer, yes. This is from Lindsay. They will receive state benefits. And then on the right-hand side, this was in the employer COVID-19 handbook that was stripped off the website, and it talks right in it about Kentucky is allowing unemployment insurance benefits to be paid to employees who are experiencing a severe shortage. Some call this a WorkShare program. This is an option for Kentucky employers to pursue in lieu of a complete layoff. If you've been hit by this, you need to start reaching out to the state, because they are now fully aware through their attorney that this is a massive issue, that they were not treating employers equally, and that I have a host of people who are very upset about the fact that they appear to have been lying to their employees about the ability to have WorkShare. So they're still dumping these on me daily. They have just scratched the surface. They said they need more time because all of their employees are on paid furlough, state employees. You guys don't have that benefit because they didn't bother to get it done in time so that you could have your employees benefit from the federal monies. I did a little research. I believe Kentucky is the only state that did not allow WorkShare. So our money was sitting there and our state let it just rot. So all of the employees that had the ability to get that money, I have no clue why unemployment office didn't do it. The governor approved it, signed it into law on May the 1st. It is the law. They didn't do it, and they had the opportunity to fix it. They were told what was wrong with our situation from a federal standpoint. Mandate said that this was literally a temporary measure. All he had to do was remove temporary, come in later and change it back from being a temporary, or change it back to temporary. But because it was adopted as a temporary, the way the federal law was set up, we could not have the Federal Department of Labor. Employers could kick in one half. The state was required under the regulation to kick in the other half, and then all of the employees could get the $600. And I bluntly stated it, and I'll state it right here on this as well. I told the general counsel for the Kentucky unemployment, you don't seem to understand. Nobody cared about the state benefit. The reality is this: if you cut somebody's hours by 20%, the state benefits are already capped at $552. So you're looking at a total of employee by cutting their wages 20%. all the employers cared about was getting people back in and having some incentive. And their incentive was you'll get the $600 from federal, and you can get back to work and get your regular rate minus 10%, 20%, 30, 40, 50, whatever it was. And I told this guy, I said, you've really screwed Kentucky employers, because the employers were begging to get people back to work, and this was a way to incentivize it until the July 31st time period. And what you did was you drug your feet for the whole time, didn't answer questions, removed your COVID-19 employer instruction manual, and basically made it so the employers lied to their employees, told them that there was a benefit, and then they got nothing for it. So to everybody on here that listened to me in week 5 on May the 1st, when this was put into law, that very first, I think it was week 5, the very first Monday in May, where I presented to you, or Tuesday, because I think Monday was a holiday, and I showed you this regulation and walked you through how to do it and all the things that we were doing to answer it, because there wasn't an application. Let me show you the application. It's really awesome, the whole thing. Here's the whole thing. All the questions that I had put into a letter, they basically took out of the letter I sent to them, put it into a pretty chart, and then had a fully functional application online. This was my letter to a T, except I didn't make it into pretty boxes, but this was what I was sending out for everybody to them. So when I saw it in almost the same exact language, I was like, where'd that come from? But that's your application. If you ever got one of those, please let me know. But that's the update on the Kentucky WorkShare. And I know I've bit my tongue, I haven't said much, but the level of frustration right now with the unemployment office, now that the federal money is gone, and the number of emails I got last week, it was not just last week, the last month, about the WorkShare, about what people are being told, about people being lied to or believing things and being misled as to whether it exists or not. And trust me, I have the emails written to me going, I don't know how many times, Mr. Morris, I need to tell you this, but there is no such thing as WorkShare. And I kept writing her back and saying, I understand that you keep saying that, but you have certain employers that are being able to capitalize on a reduced work schedule. I don't care what you call it. Why are some people not getting it and other people are? It's not the size of the organization. It appears it is only based on, did the employer e-file the claim, or did the employer try to do it in a traditional 2-week reporting period from the employees? I can't figure anything else out. And they won't answer any other questions other than, now it's all coming out, and the answer is, we believe that the head of the Workforce Development Department was confused, and she just didn't realize what she was saying in these emails. And my answer to that is, I don't buy it. So I'm going to stay on them. I'm preparing some things to possibly address it in a little bit more forceful way. But that's the gist of it. And while we're doing questions, I'm going to switch to the last slide that has the SHRM code in it, and then have at it with the questions. And I'll try to read through them too. Things are a little disjointed because for whatever reason, my presentation slide that's usually right in front of me so I can see what I'm doing next is gone. So I have to keep looking over to see what's over there. And I didn't want to shut down the slide in the middle of Mr. Congressman Yarmuth speaking, so I've just let it go the way it was. I apologize that I haven't had the same level of seeing where I am all the way through. So, where are we?
Okay. So we've got some questions. I'm going to kind of work backwards because some of them are more, they were more for Congressman Yarmuth, and I think he did address some of them. So if employees voluntarily choose to vacation in hotspots, can't company protocols just state that they will have to quarantine or wait till they get their test results on their own dime before they come back?
So, you know, that's why I wanted him to answer that. And I wasn't trying to put him on the spot necessarily, except for the fact that everybody, the first time around with the CARES Act and the Ffcra, which were adopted at the end of March, right after we started these webinars. Everybody thought at that point, this is a temporary measure. So they built it as a temporary measure, and the Ffcra sick pay and take care of someone else protection under the EFMLEA were designed to be very limited. There wasn't going to be a quarantine. There wasn't going to be a nationwide shutdown. There wasn't going to be cancellation of basketball seasons and football and school and everything else. So when they built the first one, and I wanted to ask him this, but I wanted to stay out of the what could have been seen as a political, so I didn't say it. You built the first one based upon a belief that this is a short time, and the Ffcra was for those individuals caring for an elderly person with COVID, or a child with COVID, or a spouse with COVID, and that was supposed to be it. And then I shared with all of you the reality of starting April 1st, this turns into a nightmare because everybody's subject to one of the 1 through 6 that we walk through. Every single person in the entire country is subject to a governmental mandate, a shutdown order, a limitation, a work from home, all these different things. So I get it. The first one was done before we had the shutdown, so nobody understood. Well, Congressman Yarmuth talked about the second one starting in May. At that point, we're in the middle of a pandemic and everything's shut down. So when you have the HEROES Act that was adopted that goes to Senate, now you have a Senate that's adopting a much smaller that's going to the House, and they're arguing over what they're going to do now, and the Senate hasn't sent it yet, but they're basically trying to come up with a one-time pass it and then everybody's happy. The problem that you have is, where is this discussion now? It's not about, going in and saying, well, the administration's so messed up, there's a dog groomer running the PPE. None of that matters. And I don't know whether it's real or not, and honestly, I don't care. What I care about is the second time around, the country was indeed shut down. So when you pull up Ffcra and you pull up unemployment and you pull up all the rest of it and you're going to say we're going to do $3.4 trillion of money going out, where are the steps taken to help employers now with the Ffcra, with the governor's recommendation / mandate? And that's where I think that the whole system's broke on both sides, because we had an opportunity this time to say, now we're in the middle of a pandemic. We all know that. This time, if you this is what I wished was in it, because I'm about the employer, sorry. If you voluntarily go to a hot spot and you then have to quarantine for 14 days, that's without pay. And you can be fired, because if the employer needs to move on and you went somewhere and you possibly exposed yourself, and now you have to stay at home, and it was not mandatory. You didn't go there for health reasons. You didn't go there to take care of an elderly. You went to Florida to go to Disney World in the middle of a pandemic because you want to take your daughter in the summer. You can get fired. That's what I wish they would say. If you're trying to keep people at home, don't go somewhere where you can get exposed voluntarily. They should have put in restrictions on the Ffcra second time around. Both sides agreed to it. We're going to try to protect people. But if you voluntarily put yourself in that position, your employer does not have to pay you under the sick leave. Your employer does not have to pay you under the Ffcra self-quarantine because of a doctor's note. Because here's the thing, and I saw it in the chat, I agree with you. Build a policy that says you go somewhere, you're not going to get paid when you come back. Well, guess what? All they have to do is go to the local CVS where they can get tested, and they can tell the healthcare provider behind the glass wall, the plexiglass screen, I just got back from Florida. Can you write me a note that says I need to quarantine for 14 days? If they write a note that says, I recommend this person quarantine for 14 days, under the existing law, I don't care whether you have a policy that says if you voluntarily went to Florida, you have to quarantine without pay. Because now they have a doctor's note, now they fall under the Ffcra 1 through 6 that says if they have a doctor that recommends that they quarantine, then you have to pay them under the sick leave and or Ffcra leave. That's the nightmare that's out there. That's what I believe personally should have been addressed by Congress in the middle of the pandemic. I'll give you a free pass the first time around. And I point blank said all the way through, when Congress passed the Ffcra and the CARES Act, they had no clue what they were dealing with. Nobody thought employers were going to get dinged with the 12 weeks. Nobody thought that this was going to continue through the summer and then the fall. I get it. Now you have a chance to fix it, and nobody's fixing it. So I'm frustrated with both sides. Probably figure that out. All right, next.
All right. So do you think summer camp providers would count as child care provider? They have, some people are having employees whose summer camps for their children are being closed and they're trying to qualify for Ffcra.
Yes, so if you remember the sarcastic week, I had a sarcastic week at the beginning of the summer school, or summer, when school was closing, and the Eeoc came out with guidance. I know there was someone else, there's another alphabet in there that came out with guidance, and somebody on here will throw it into the chat, I'm pretty sure. But there was a guidance from the Eeoc that said, and it was very sarcastic in theirs, and then I just kind of changed a couple of words to say, hey, I want to go to Disney World instead of I want to go on vacation to Florida. But the frequently asked questions on there were literally, so, hey, while my kid was in, when the school was closed, they had to pay me to stay at home because school was closed. But now that school's out, is there any way for me to still stay at home? I want to go on vacation with my, literally, no, see, you can't stay at home because the school's closed, because school's no longer closed. But if you can find, and it literally, this is the way it was written, if you can find a summer program that's closed that you wanted to send your child to, then you can reapply for Ffcra Family First Leave, because now your summer program from your child is closed. Literally, that's what the frequently asked question said. So the answer to your question now is yes, summer school does qualify as a provider or a school or a child care organization that if you can no longer get the child care taken care of, i.e. the school's closed. We've had 2 incidents. One was in Georgia where there was a massive outbreak among children as young as 6, I believe. And there's also one, I believe, out of Winchester, Kentucky that went to Cincinnati or up into Ohio, and they had a super spreader there that ended up getting several ill as well. So the answer to your question is yes, it does qualify. Yes, you can get leave if the school's closed, and I think I recommended to the human resources people, ask employees some questions about it. Make sure that they actually had it planned. Ask them for documentation showing that this was something that they were going to do, because under the FMLA, you have the right to ask follow-up questions and to interview your employees. So hypothetically speaking, if it's a low-performing employee and the employee says, oh, yeah, you know that one that just closed in Cincinnati, my kid was going to go to that, I think you ought to be able to go, you have an email showing that they were going to go, or do you have documentation? Because honestly, if you don't, then we have serious question about whether or not this is a legitimate ask under the FMLA or FMLEA. Be careful with that, but if you seriously see people abusing it, I think there's going to be some backlash on people abusing the summer schools and the my kid can't go. But honestly, everybody's going to run out of that leave sometime around September, October, so you're going to see a lot of people laid off anyway or without leave, without pay because of the remote work or the remote school that has to go on starting in late August. Yeah, Fawn, I'm going to answer that one because I actually know about this one, unless there's several, though, probably out there. There was there is a child care that's, unfortunately, they're doing it classroom to classroom instead of the full child care closing. But the question is asked, if an employee was told she must resign if she misses more than a few days due to her child care having to close for 2 weeks due to COVID. That would be illegal, because if they have a shutdown of the school, they fall under the school shutdown of the Ffcra. Now, it's illegal unless he or she has expended all 12 weeks of leave that they're entitled to. If they meet the qualifications under the Ffcra, they've been employed more than 30 days, they haven't expended all of their leave, you cannot fire someone because they have to take care of their child unless they fall within the exemption under the Ffcra, which, if this is the same child care, it may be, which is first responders. I don't know why Congress did it. That was the other thing I'd love to ask someone, and I've bit my tongue for 3 months, whether it's Barr or his chief of staff or Yarmuth now. Why in the world would you exempt first responders and healthcare providers from the Ffcra leave? They're parents too, and telling them that they can't leave their job to take care of their child so they can be fired if they have a child who's ill, or their school shuts down, or they can't find alternative child care, honestly, I think is one of the worst things we did for first responders. So I don't know whether you all knew that or not, but first responders get no relief under the Ffcra. They are exempt, and it's so unfair. I think that it should be, that should be set aside as well. So, yeah, I see the comment about when you were closed and furloughed. You just need to add up the number of days. If they combined are above the amount of time that they're entitled to under the Ffcra, FMLA, EFMLEA, which is 12 weeks total, 2 weeks of which is sick. The rest 10 weeks remaining can be used at 2/3 if you're caring for a child, or full if they're caring for themselves, et cetera, et cetera. If that's the case, then you may be out of time and she may not be entitled to any. So then it's up to you as to whether you want to give 1 or 2 days a week to someone to take care of a child, or you want to terminate them because you can't keep them in their position. Those get into the weeds about an individual and whether they're worth keeping and a whole lot of other things. So go ahead. Next one.
Okay. So how would you recommend employers handle employees who are absent from work for recognized symptoms of COVID, but who are not seeking medical treatment? So they're required to not come into the office or to leave work because they have a symptom, but they're not seeking medical treatment.
So,
are they covered by the Ffcra?
Right. You have an obligation to protect the rest of your employees. That's first and foremost. We've talked about that. One of those is anyone who presents with symptomology of COVID-19 can be removed from the workplace and required to seek treatment before they come back to work. You need to give them a reasonable amount of time. What that time is will depend on each individual circumstance. I'd recommend you have a policy for it. I know I talk about this a lot, but remember, you have multiple managers. They all have to treat everybody the golden rule. Everybody has to be the same. What happens if you don't treat everyone the same and one manager says, yeah, that's okay, the other one says, no, we need everything? Then you can get sued because you aren't treating everyone the same. So put a policy together. But if that employee does not follow up, you can terminate that employee, because you don't have to pay someone who is not adhering to the mandate set by the government to go into work. And that is, if you have symptoms, you must leave and you must be tested. You must follow the guidance of the healthcare provider before you come back to work. And if you remember, under CDC and EEOC policy, I advised you around week 10, you have an absolute right to preclude people from coming to work. You have an absolute right during a pandemic only to ask questions before they can come in, and you have an absolute right to turn them away and require them to seek the treatment necessary and come in with a return to work notification. The caveat to that is you don't want to be a jerk about what type of document you get because, and this is in everybody's guidelines, healthcare providers are busy, so don't put it on a formal letter requirement, letterhead requirement, formalistic note. If you get something from a healthcare provider that says this person's safe to go back to work, return them to work. If they refuse to go get the treatment, or the testing, not treatment, sorry, you do not have to keep paying that person for 14 days if they're not really in need of that 14 days. One of the issues that I've seen lately, and it's the same thing that I was talking about with the hotspot, people are getting a negative test, but in order to continue, you probably won't see it now that the federal government no longer has $600 a week, but what I was seeing was a whole lot of a doctor's note that says, person passes the test, they didn't have a positive COVID. I recommend they stay home for 14 days. Shame on our medical care people for recommending people stay home without any symptoms and with a negative test, because that's basically just disrupting and allowing people to continue to get unemployment when they truly don't need it. But to answer your question, if the person refuses to get tested, refuses to follow the mandate that the governor set out, let them go. Just document the heck out of what you did, because you might get challenged under the COVID-19, but the alternative is you're paying people, and yet the Ffcra is going to come in and say, we're not reimbursing you dollar for dollar because this person had a negative. He's not under a quarantine. He's not under a mandate. You didn't follow up. Why did you keep paying this person for 14 days if they didn't qualify under the Ffcra 1 through 6 category? So remember, if you're going to seek dollar for dollar reimbursement from the federal government, you're on the hook to verify that people actually qualify for that leave. Next.
Well, I sent you 2 questions. I didn't know if they were really for you, but otherwise that's all the new ones that we have.
Okay, so one of them was about the PPP, and the money's been spent, submission's been made. Awesome thing is this, and don't quote me on this, but you need to seek some guidance from someone on your PPP, because when you submit it to your bank has, and I can't remember, I did give you all of the breakdowns, but I think this was week 4 or week 3. Go back and look at the slides. Your bank has a very limited time period to approve your loan. Check on that, because they cannot drag their feet. So the question was, I'm sorry, let me read the question, not in full, but we received the PPP, we spent all the money, we submitted it for loan forgiveness, and the bank won't issue anything. What do? Bank's waiting on a guidance from the SBA, and how long is it going to take? Reality is you don't have to wait. If you spent your money, your bank has a limited time period to act on your loan forgiveness. So check on that. I can't remember the number of weeks that they have or days. I think it was 30 days, but don't quote me on that. So if they do, if they don't follow through, I believe your whole loan is forgiven because they didn't do it, but don't quote me on that because I don't remember it word for word. We talked about it. But do go back and look at the slides because I walked you through everything on the bank side, how long they had to review your 8-week loan if you took the 8-week process. For timing purposes, I'll just let you know it was before the expansion of the PPP to allow for the 24 weeks. So whatever that time period was, don't look at the amended PPP slides, look at the one right before that. So, another question. We've had employees who've been out on Ffcra after having 2, 3, 4 different exposure incidents and having to be tested. Having been shut down, we can't afford to keep paying this outside of Ffcra. How is that being addressed, or will it be addressed? Yeah, that was one I really wanted to read out to the Congressman, because that was that's one that kind of gets to the heart of my issue with the Ffcra. I understand that it was a temporary measure. I understand that nobody knew at that time, but when you adopted the HEROES Act in the middle to end of May, you certainly knew it. So what steps did you take to tighten it up in that version so that when it went to the Senate, now we're not fighting over just dollars, we're actually agreeing to limit the Ffcra or to pay people under it or something. What I see happening is, because of the July 31st deadline and the expiration of the federal monies, and because everything is right now all about dollars, all of these little things, the Ffcra expansion, the PPP expansion, because they've talked about expanding that and giving a round two for people who took the money, spent it during the 8 weeks because that's what they were told they had to do before their business opened, and now they've tried to open and they have no money to support it. How do they get their money back? They should be spending time in the weeds on these issues, day in and day out. That's what we pay them for. They shouldn't just be throwing around huge dollars and saying, well, we won't agree to 3.4, we'll only agree to 1.6. I don't care what dollar amount we're talking about. We should have been nailing down the cleaning up of the CARES Act, the cleaning up of the Ffcra, the cleaning up of the monies under unemployment, coming up with a sliding scale that pays more to employees to get them into work than it does to have them be unemployed. Unfortunately, some of those things are not being included. So Lindsay sent a note to everyone about the ESPL. The dollar for dollar was under the Ffcra, not the ESPL. There was some discussion about, at one point you had to pick between the two, and then they said, no, you can do both. It is being paid, a lot of them are doing it as gross pay minus pre-tax. I'm not sure how you're going to get the full reimbursement with that. I think what you're going to have to do is talk to your payroll processing company vendor if you're using a third party and verify that they're doing it the right way, because you're supposed to be able to take it out of your payroll taxes dollar for dollar, and if that's not enough, you can actually get a loan toward future pay to cover it. But if it's been paid wrong, you may have to go back in and amend things, and it's so confusing. I could see people doing that and getting it wrong. Crystal asked a question, what if they have the opportunity to telework, but we need them to return to the office because they're a supervisor? They refuse treatment, they refuse testing. Can you seek termination? Great question, because I wish, now that I'm going to jump off of Congress and now I'm going to jump on our governor, not political, but you come out with a phase early on that says that all companies must telework if at all possible. All employees must be given the option to telework. We've not had any update to that phase since May 1st, as a matter of fact, if I'm not mistaken. The problem with that is some employers cannot simply allow telework because telework is something that can happen. I'm going to give a couple of examples. I've had one where they're like, look, you know what, Allison, I'm going to pick on people who are on this call. Allison does a great job working, and no, this is not from Lyle. You know what, I'm going to make up names. I was going to make this a Hanna Resource, but I'm not going to. So John, Jane, and Fred are all teleworking, and Fred and Jane do an incredibly good job. They're self-motivated. They put in their 8 hours. Actually, you know what? No. Jane does a great job. She puts in her 8 hours. Fred's doing a terrible job. Doesn't do anything. John does an incredible job, but he's also working 18 hours a day, and the company can't pay him that, and they're scared to death. They can't turn off his computer. He's an hourly employee, so they can't stop him because he keeps saying, no, I got to keep working until I get it done. Well, you got three problems there. One's doing her job great. Let her stay at home. One's lazy as can be and is not working at all. So either he needs to come in or we need to fire him. We can't just let him telework and do nothing. The third one's working 18 hours a day, we have to pay that person 18 hours a day because we control the work. And unless we can turn that computer off, we have to pay that person overtime. He's going to hit us with a wage an hour. So we have to stop him from working, and if he won't stop, then we have to remove his computer or shut him off after 8 hours. Then he's not getting the work done he needs to get done. We need him to come into the office. So the reality is government cannot control individual workforces and tell you you have to send people home and allow them to work from home, because they don't supervise daily to find out whether this supervisor can do their job from home. So I can't give you individual about that particular supervisor, but I see serious problems that we have with regard to telework and no further guidance when we're into phase whatever, and we've gone to 50 people, back down to 10 people, front-facing business, not front-facing business. We're not getting enough guidance from government about the ability to open. So that creates concern for me, and I see it. I know that you're right on that, but I can't give you individual about that supervisor.
Okay.
Any others? Are we done?
Are we ready to wrap up?
Think so?
I want to
Up to
mention,
you all.
somebody asked about the Kentucky SHRM Conference. It was scheduled for late August. Now, Autumn, help me with this. I think it's scheduled for October 12, 13, and 14, and it's primarily virtual. And it's not been totally finalized, but that's what it's looking like now. They're going to do a virtual conference in the middle of October.
13th, 14th, and 15th.
Okay, 13, 14, 15. Thank you. I think that wraps it up. We've got our codes here for your certification credit. We really appreciate everybody joining us today. We're going to do something a little different here as we wrap up. And that is, we're going to take the slides out of there, get the slides out of there. We're going to throw it open for about 5